Good afternoon and welcome to the Ezra Digital 2021 Education Series. I would now like to turn the program over to Steve Bisbee for introductions.
Thank you, Mallory. I'm Steve Bisbee, the president and founder of eOriginal, a provider of a leading digital transaction management platform for financial services. We oversaw the development of unique digital solutions that have replaced paper processes, expedited transactions, and created business process efficiencies for over 600 clients in the digital financial ecosystem. The Electronic Signatures and Records Association was formed to educate and advocate for the use and acceptance of digital signatures, records, and transactions, and I've been on the board of Ezra since its inception. I am one of the co-chairs of the Education Series, along with my colleague, Margot Tank. Our members are dedicated to providing, promoting, and participating in Ezra values of expertise, leadership, collaboration, accessibility, and technology neutrality. As part of Ezra's education mission, we have created this series that will run through the end of this year. The education series provides insight and practical guidance on the business, technology, and legal implementation issues across a very wide spectrum of applications. There will be presentations from Ezra members and their partners on topics ranging from remote online notarization, as in today, digital mortgage, auto finance, to the use of voice signatures and other biometric means to authenticate signers and execute documents. Although eSign was enacted 20 years ago, there's still a learning curve as companies continue to transform the business practices. These issues are even more critically important during this time of social distancing, remote work, and contactless consumer engagement. And we hope that you find these webinars useful. And finally, I would like to introduce our moderator today, Tim Reininger from eNotaryLog. Tim serves as a digital counsel for eNotaryLog. He specializes in information law and policy, governance, privacy, and security. He is nationally recognized expert on the Notary Office and Information Policy, testifying on these topics before the United States House Judiciary Committee, the California House and Senate Judiciary Committees, the Florida Senate Judiciary Committees, and the Hague Conference on Private International Law. Tim has authored and spearheaded the first in the nation's laws on remote online notarization in 2011 and digital identity issuance and management in 2015. Both in Virginia. As a result of these efforts, he was appointed as an ABA advisor to the Uniform Law Commission's drafting committee to amend the revised Uniform Laws on Notarial Acts in 2018. eNotaryLog is a notarization as a service company. As a Florida-based online notarization company, it works to help business owners feel organized and relaxed in their document e-signature and notarization endeavors so they can focus on what they do best, which is running their business. Please welcome Tim.
Thank you very much, Steve. And I want to thank Ezra, which is such an amazing organization that's been very influential, and its members, the leading entities and companies that deliver e-signature services and now online notary services, and eNotaryLog, based in Tampa, Florida, is the newest such entity, and I'm very proud to be supporting eNotaryLog. And just a quick note here, we're talking about digital identity. Now, the members of Ezra are almost all of them experts on e-signature laws, have done the leading attorneys in the country on these issues. So this is not intended to be another session on the basics of e-signature law. You already know all that. We're talking about digital identity. And digital identity is a large subject. What we're not talking about today is health passports, which are in the news, vaccine passports. We're not talking about credentials for access to buildings and networks. We're talking about the intersection of digital identity with e-signatures. And I know that this is an issue that has been challenging Ezra members in many fronts, especially with respect to online authentication of signers and identity proofing, what to rely on, the interplay with the laws. And so we put together what I believe to be the best possible panel on these topics to highlight what are the key issues you need to know, issues that are not necessarily resolved, that are policy issues of disagreement, perhaps, that are being worked on, where these speakers see the technology and the policies trending. So you'll get a sneak peek at that and the laws, both within the United States and internationally. And we have two attorneys who are experts on the laws internationally. And of course, cyberspace is, as we all know, a global entity situation with no physical boundaries. So at any rate, I am delighted. Our program does not, unlike others, consist of a series of detailed slides. This will require you to listen more to the speakers very carefully and their questions to each other, and you'll have an opportunity to ask some really great questions. Our first speaker, if we can go ahead, please, Mallory, to the next slide. There we go. So our first speaker will be Mike Garcia, who's not a lawyer, so it's perfect. He is an expert, one of the foremost experts on the policy of identity systems and design. And some of you may know him from the National Strategy, Trust Identities and Cyberspace effort under the Obama administration. And so he is sitting on the understanding of the NIST guidelines, which I know have bedeviled a lot of people in the online notary community. So he will explain about that and give us insights of emerging authentication techniques for signers. Then next speaker, next slide will be Tom Spettinghoff. I'm sure is well known to all of you, and I've had the pleasure of working with Tom since 2009 with the American Bar Association Identity Management Task Force. And I remember when that was launched by Tom in New York City, and I never thought it would be lasting this long and actually becoming more important than ever right now, frankly. And it's wonderful that Tom is still there to run it. And he's also a member of the US delegation to UNCITRAL, and he will give you the latest thoughts, policy discussions there. There is a model law that's almost ready for approval. He'll update us on that and how that will affect all of the companies and members of ESRA. And then our last speaker will be Stephen Mason, who is a barrister in England. I actually had the pleasure once, he gave me a tour of Middle Temple. That was one of the most memorable experiences I've ever had. But he is a very widely published author on the intersection of evidence and technology all around these issues of digital identity and electronic signatures. And one of his favorite themes is how we live in a computer-mediated age governed by software systems and all the issues of risk and trust related to those. I'm sure some of his comments will touch on that. So to lead the maximum amount of time for these excellent speakers, and I've set up about 10 minutes each for them to hit 3 broad topics each. We'll start with Mike Garcia. Thank you. There you go, Mike. Thank you.
Thanks, Tim. Appreciate you having me. Thank you to Ezra for that. And thank you all participants for taking time today to listen. I'm honored to be on a panel with Tom and Stephen. They're pretty widely known and widely respected. And as Tim mentioned, I am the non-lawyer. And so I'm going to talk about things that are a little less lawyery, for better or worse. So my goal here is to provide the kind of framework for the discussion. What is the state of policy, which really comes under NIST 863, which I was an author of and the executive sponsor back when I was running the show for identity at NIST when I was within the government, and to not turn you into a technologist or expert in digital identity technology, but to give you the vocabulary to start asking the right questions. And if you can walk away feeling more equipped from the next 10 minutes for that, then I'll have considered this a success. So I'm going to speak fairly quickly about some of these topics and spend a little more time on others. So buckle up. There's a lot to go through. So first, digital identity. Formally, it is the online persona of a subject. It does not have to be linked to a real person. It's just unique within a context. User 123, right? You try another username, that's already taken. The whole point of that is to make you unique within the context of whatever that portal or application is. And again, it can be anonymous or pseudonymous. So it really is about creating one thing, one entry into a system. Within that, there are two fundamental components, three really, but one we're going to mostly ignore today. And the first one is authentication. Authentication is all about making a return visit. Oh, great. User 123 is here again. It's the same user 123. I feel confident about that. I'm going to show them, I'm going to leave them where they left off last time. And then there's identity proofing, that you are a real person. That user 123 is Mike Garcia, and not just Mike Garcia, but this specific Mike Garcia. If you're named Mike Garcia, you understand how difficult it is to get people to recognize whether you're that Mike Garcia or one of the other many millions of Mike Garcias out there. It's kind of the new John Smith. The third one is federation, which you'll hear sometimes talking about. We're not going to really spend much time talking about it today. The basic idea of it is it's kind of about the transitive property. I trust this organization trusts you as an individual, so I'm going to trust you as an individual. That's what federation is about. There's a lot more detail behind it and how you establish it, especially from a governance perspective, but we just don't have time for that today. So let's dig into authentication first. Again, nothing to do with being a real person or even a specific person. It has to do with being a specific user for return visits. I run an online application. I want you to come back. When you come back, I want it to be like you never left. And in order to do that, I bind what are called authenticators to an account. Some you know very well: passwords, security questions, knowledge-based authentication or verification. We won't talk much about that. I'll mention it later in the identity proofing piece of it, but really that's actually about authentication. Most everyone at this point is familiar with something that you have as an authentication factor. So a badge that you shove into the computer, a mobile phone that receives a text message or a one-time code from an application, a physical security key that you plug in, an RSA key where you type in some code, right? These are sorts of things that are possession-based. And then the third one is something you are. So these are generally biometrics, face, fingerprint, iris. We're all quite used to at least fingerprint and face through smartphones these days. So those are kind of the three main types of authenticators: something you know, something you have, something you are. We require at least one of those in order to call it authentication. That's how I know that user 123 is showing up and is actually user 123. When you use more than one of those, so something you know plus something you have or something you are, typically is the way that's implemented, that's called multi-factor or two-factor authentication. You're using at least two of these three somethings. So no matter how many times or ways that it happens, authentication is that process of logging into an online site, and that's it. So while new approaches pop up from time to time, on the whole, users are very used to authenticating. They know what it is, even if they don't know that word authenticating. A lot of things happen in the background to reduce risk. Did you log in 5 minutes ago from an IP address in the US and now there's an IP address in Russia trying to log in as the same user? Are you trying to log in over and over and over again unsuccessfully, meaning you're probably trying to brute force your way in and you're a bad guy? Has this device been there before? We do all sorts of things to kind of augment that basic process of something you know you have or you are. But all of that kind of falls under the realm of authentication. So now let's turn to identity proofing. These are completely separate things. You don't have to authenticate to identity proof. You don't have to identity proof to authenticate. Identity proofing has nothing to do with returning to a service. Sometimes you do it just one time, you hit submit, and that's it. It goes away. Maybe you get mailed whatever you signed up for, or maybe someone calls you or something like that, right? It may have no association with authentication whatsoever. Often it does, but it doesn't have to. This is about determining that whoever is on the other side of the Ethernet cable or 5G connection or whatever it may be, is a specific carbon-based life form. So showing information to the wrong person presents a risk to the right person and probably to the organization that does the showing as well, right? So there's risk and liability to the service as well as to the individual who might face harm as a result of that. So what we do to prevent that is we have 3 steps for identity proofing. We conduct resolution, which says of all the many, many Mike Garcias out there, which specific one are we talking about? Then we have validation, is this Mike Garcia a true actual person? Does such a Mike Garcia actually exist with X birth date and X social security number, et cetera, et cetera? And then verification. Is the person that I'm currently interacting with actually that Mike Garcia? So you have to, in order to identity proof, you have to establish all three of those things. Figure out what Mike Garcia you're talking about, figure out that Mike Garcia is a real live person, and figure out that the person on the other end of this transaction is in fact that Mike Garcia. So online identity proofing really is about trying to replicate what we already do in person. And those analogies are really important to think your way through these problems. So think of it like going to the bank in person, right? The teller is going to look up my name, maybe my date of birth, to see if I'm a customer in the system. That's equivalent to resolution. They're figuring out what Mike Garcia we're talking about. Who are you that just walked into my bank? Are you in my system? Do you exist to me, and are you unique? Then we go to the validation part. They take my ID, they bend it a little bit and see that it's real plastic, it looks real, it feels real, it matches the name that I gave them that is in their system. Great, you've been validated. This looks like a real ID, that's good enough for me. And we have verification. I look at the picture on the ID, if I'm the teller, I look at the individual standing in front of me, I say, okay, great, I can do a good biometric comparison. Now I ask you how I can help you today. So obviously, people in the notary world are very familiar with this, right? We do this. We do this sort of thing when you walk in and you prove yourself. The resolution piece of it maybe isn't quite the same because you're not necessarily tying it back to some existing record like in a bank. But the reality is that you're doing these things where you look at this ID and you say, all right, this looks like it's one specific person and this thing looks real. And that's the person that's standing in front of me. Most applications online do not require proofing. And that's a good thing. It's a waste of money. There are privacy risks. There are failures that happen because 100% of people don't manage to get through it. And so you have drop off. So you really should only use it when you truly need to. Fine. But there's a risk. There's a lot of risk analysis that you can do to determine when that need happens. As far as online notary goes, we're kind of going to skip this part because we know from the types of transactions that we're conducting that they are valuable and they probably need some level of identity proofing. Otherwise, they probably wouldn't need a notarization, right? And so in person, what you typically do is you just proof again, right? Someone shows up for the second time the next day, you take their ID again, you look at it, you go through the whole thing, you keep the record of it, you put it in the book, you do everything you're supposed to do. Online, identity proofing is the expensive part. Authentication is the cheap part. And so you leverage authentication to lower your costs so you don't have to continue identity proofing over and over again. So what you do is if you're going to identity proof, you either offer to create an account or you compel the user to create an account so that they don't have to identity proof again. And now you've linked this authentication piece to the identity proofing piece, and you can save money if they come back and do it again. So I want to talk a little bit about what a common proofing looks like today. Honestly, we've more or less nailed the authentication problem, which was not the reality a handful of years ago. And so there's still a lot that can be done to improve it, but we're pretty good at it. If it's important, do multi-factor authentication. That's kind of the short story. If your users create an account for notary purposes, it should almost certainly be multi-factor. So with that, we'll focus a little bit on proofing. The idea on proofing is that you can either not do it, you could do it fairly well, or you can do it really well. And I know those sound kind of generic. There is a risk framework behind deciding that, but it has to do with the level of risk behind the transaction, the level of value and consequences of doing it wrong, right? And so what we typically see is this type of identity proofing, but basically all the commercial vendors provide, where you capture your ID, you capture some other personal info, usually a phone number, a social security number, you capture your selfie. In the background, the service checks to make sure the ID is real by scanning that image and doing some security checks on it. They check to make sure the other personal information matches. For instance, if I give you a phone number, you make sure that my name is associated with the account and the phone number, or my name and birth date are associated with the social security number that I gave. And then you compare that selfie to what's on the ID. You do a biometric comparison, just like a human would do, but now you're relying on a machine to do it over the wire. So the cost of this can range, but the thing to really know is that if it's too cheap, if it's below a couple of bucks, then typically that means they're not doing it right, and you have to be aware of ineffective solutions. So there's a ton of detail behind this you can get into, and that's all documented in 863. But the important thing is to make sure that you really have to conduct that technical analysis of someone who's providing these solutions in order to know that you're getting it right. And the whole point here is risk mitigation, right? That is the entire point of having a notary process, is that you're trying to mitigate the risk of something that is a large transaction, and you're willing to pay something for that or provide it as a service or create a little bit of inconvenience for it. And so balancing that, what cost is it worth to get this notarization done with the value of the transaction is how you make the decision on how much you do. Now, there's currently an update that's going on to the 863 document from NIST. I'm no longer in the government. I don't have insight on exactly what that looks like. But as far as the updates we're expecting, we're probably going to see more things around biometrics and liveness that may make it harder, but will make it more measurable on how to get authentication and proofing right from a biometric perspective. There is talk that I think is most important to this group about creating another kind of level of assurance for identity proofing that allows lower risk and lower impact transactions that would kind of suck out this biometric comparison piece of it that's a little bit difficult to manage and replace it with some use of like a dynamic KBA. I have very strong feelings on this, but I'm willing to look at the risk analysis and see what it looks like. But if there are very low transactions that kind of barely rise to the threshold of needing notarization, it's possible to fall into this. And so it's something to think about for the future. Know that this new version is not going to be coming out until the end of 2022. So there's probably over 2 years, certainly, and maybe more like 2.5 before that guidance would actually go into force, because it happens a year after the document comes out. And then another piece of this is potential updates to how identity proofing is done to allow for greater innovation. What this means isn't clear yet, but NIST is always trying to allow for the commercial space to be innovating and creating new technologies. So with that, I'll stop. And I think, Tim, that's back to you.
Thank you very much, Mike. That was really helpful on a number of points. So now I'll turn over to Tom Spenninghoff for approximately 10 minutes.
Okay, thank you, Tim. My mission today is to look at how the law governs identity and some of the directions in which that law is moving. And to start it out, I want to kind of focus on the fact that there, at least the way I look at it, there are two different dimensions of law that govern identity. There is a lot of law, in fact, we're finding more all the time, that exists currently that imposes a legal duty on businesses to verify someone's identity. And that is kind of separate from the law that governs identity services and identity systems, which in many cases is just developing. So what I'd like to do is kind of take a quick look at both of those categories of law governing identity. So the first category is the duty to verify identity. And the basic question is, well, where is that law? Where does it come from? And interestingly, newer privacy laws make this a big issue. GDPR, the California privacy law, the Virginia privacy law, I haven't looked at Colorado, but I expect it's in there as well, impose a duty to verify identity when someone asks for a copy of their data or asks for their data to be deleted for very obvious reasons. Laws requiring controlling liquor sales or tobacco sales or other things like that impose age requirements that are an attribute of identity. Banking law has know your customer regulations, which are all about identity. And even data security law has a large identity component in terms of access control to systems and imposing obligations for access controls. So if you're in a situation where you have a legal obligation to verify identity, what do you have to do? And maybe the first question there is, well, what attributes of identity do I have to verify? And strangely, there's a lot of law out there that doesn't say a word about that. It just says you must verify someone's identity and leaves it at that. But some laws do get very specific. The KYC regulations governing financial institutions, for example, have certain requirements. For example, that someone their name is not on the OFAC list, they're not involved in money laundering, that kind of thing. Other laws may require verification of citizenship, name and address, whatever. And of course, the privacy laws require that you verify that a person making a request to access or delete their data is in fact the person about whom the business has actually collected that information. But then the second question, which is even messier, is the question of, okay, if I have to verify certain attributes about someone's identity, what process or standard should I be using? And again, most laws say virtually nothing about this, but some do, and some get very specific. The California privacy law, for example, has 5 pages of regulations on how you have to verify someone's identity. And to kind of reference some of the issues that Mike just talked about, they have 2 different standards or levels for verification, one that they call reasonable verification and the other they call reasonably high verification. So you need to focus on that. On the other hand, if you look at the I-9 regulations from the federal government that apply to employers and require identification of employees, they provide a specific list of physical documents that have to be reviewed. And my recollection is it has 2 columns, and you can take two documents from column 1, or you can take 1 from column 1 and 2 from column 2. They have a series of rules. I may have those wrong, but in any event, very specific rules. And similarly in the KYC situation in the financial industry. So what are the issues regarding this duty to verify identity as we move into a digital world and where we may be relying on a third party? Well, some very basic questions. Can I rely on digital identity credentials? This has been a big issue for the I-9 regulations, and they passed some temporary regulations during the pandemic, allowing businesses to rely on digital information rather than seeing the documents in person. Can you use or rely on a third party, such as an identity system or an identity service? The California privacy law specifically says you can. Most laws, of course, don't say anything. And if you do use a third-party identity system, does it make a difference which one you use and how good they are? Do they have to be certified or approved by somebody? And of course, is there a safe harbor? Can I satisfy my legal obligation to verify identity if I do certain things, use a certain process, or use a specific identity system? All of those are kind of open issues for the most part. So let me now switch to the law governing identity systems. And I really look at this law in 3 levels. So the first level is really existing non-identity law. And by that, I mean law that wasn't written specifically to regulate identity. And of course, privacy law and data security law probably have a huge impact on identity systems and identity services, because if you think about it, everything they're dealing with is personal information. But you also have issues under contract law, tort law. When you assert someone's identity, is that negligent or fraudulent in terms of any misrepresentations that might be present? Consumer protection law, are there any warranties involved? Antitrust law, tax law, you can go down the list. They all could have an impact on the operation and services of identity systems. The issues that come up in here with respect to identity systems, obviously the collection, use, and transfer of identity information. As I just alluded to, privacy law has a lot to say here, but there are other laws too that, for example, govern the use or reuse of public identity data or social security numbers or other government issued identity numbers. And so there's a variety of law that regulates these activities already. The accuracy of identity information can be regulated by privacy law, also by tort law in terms of, again, fraud or negligent misrepresentation or defamation. The retention and availability of identity information. again, is frequently governed by privacy law, as well as data retention laws and data destruction laws. And one huge issue for identity systems is the liability of the parties, particularly the entity that is providing the identity information or asserting someone's identity through the issuance of a credential. And here, tort law, contract law, warranty law, and so forth. So there's a variety of ways in which the law impacts identity. Then I move to what I call level 2, which is newer digital identity law. This is law designed to regulate or govern all identity systems or identity services, but for the most part, it doesn't really exist. The state of Virginia has passed a statute called the Virginia Electronic Identity Management Act, and that law does govern very limited aspects of the operations of identity systems and focuses primarily on their liability. And the UNCITRAL model law that Tim alluded to and that I'm working on with the US government is, as Tim mentioned, getting close to completion. And I'll get into more detail in terms of what that covers in a minute. But that's the other major thing that's out there and may have a big influence on what countries do. But some of the issues that need to be addressed by these kind of laws are what is required for the legal recognition of identity systems or identity credentials or identity transactions? Do we need to certify identity systems as good enough for certain uses? And if so, how do we do that and who does that? What about the cross-border recognition of identity systems and identity credentials? And then, of course, you get into all the issues that Mike alluded to earlier in terms of identity proofing and credential issuance and authentication of someone's identity. And what are the processes we use there? And can those vary from situation to situation, or do we always have to do the same thing? And of course, what standards apply? And there's a variety of issues there. And that brings me to the third level of law, which is what I call identity system rules. These are individual sets of rules that govern a particular identity system. And think here of like the Visa or the MasterCard rules. If you look at the law governing credit card systems, which are not identity systems, but there's a lot of basic, existing law like contract law, privacy law, tort law, and so forth that governs the issuance and acceptance of credit cards. There's also what I call level 2 law, which is designed to regulate credit card systems, such as in the US, I guess it would be Regulation Z. But then there's that third level, which is the individual credit card system rules. And if you go to the internet, you'll see that on the Visa website, I know last time I looked, they have an extensive set of system rules that weigh in at about 1,300 pages. So there's a lot of issues that they address in the context of system rules. And these apply to all of us and all the banks and all the processors by contract, not by state mandated law. But they govern a lot of those issues. I mean, for the credit card systems, they govern card size and what goes on the chip and all kinds of things. But they also, impose a variety of rules regarding enrollment and, identity proofing and authenticating and liability and dispute resolution and on and on and on. So that's kind of the basic structure we're looking at when we talk about identity systems and the law that applies to them. There are a number of identity system rule sets that you can find on the internet, and they go by different names. Sometimes they're referred to as system rules. Sometimes they're referred to as operating policies, trust frameworks, governance frameworks. Everybody seems to be using a different name, but the bottom line is, for private sector identity systems, these are rules that the system itself designs and that parties agree to contractually with respect to the parts of those rules that apply to them. So let me close by turning to the UNCITRAL model law and give you a quick overview about that. So UNCITRAL is the UN Commission on International Trade Law, and it's been working on the issue of identity for probably the last 3 years or so. It's developing what it refers to as a model law, but given history, that model law can have a huge influence. In 1996, UNCITRAL developed the model law on electronic commerce, and that law has formed the basis of every electronic signature law in virtually every country, including eSign and UITA. It's all based on that UNCITRAL model law. So it can be very influential. The law that we're working on applies to both the duty to identify and to identity systems or identity services, depending on what term you want to use. It does not impose a duty to identify. That comes from those other laws that I talked about earlier. And it does not change any identity verification systems that exist in the law, like those I-9 requirements or those California CCPA requirements I mentioned, and it stays away from privacy law. So it basically says, you know, you have to comply with privacy law. So it makes the use of a digital identity system voluntary, but it basically would give legal recognition to digital identification. Basically, it says if someone uses a digital identity rather than a paper or plastic credential, you can't deny giving it legal effect simply because it's in digital form. There may be other reasons, but you can't deny it because it's in digital form. And then with respect to identity service providers, it imposes a minimum set of requirements on them, although for the most part, those requirements say you must develop your own system rules and cover the following issues in the way that's appropriate for your system. It also imposes obligations on the individuals identified. Again, think of them as like the credit card holders. It imposes some minimal obligations on those individuals or users. But finally, the basic concept behind the model law is to rely on the concept of reliability. And the whole statute seems to revolve around the concept of reliable systems. So the duty to identify that we talked about at the beginning is satisfied if you use a, quote, reliable identity system. But of course, what is reliable? So the model law identifies a number of factors and gives countries the option of setting up systems to designate which systems are reliable. I'm not sure how all that's going to work. And of course, this is a very controversial subject generally with respect to identity services. But the plan at this point is to finalize everything in the fall, at the fall meeting, which will be in Vienna, and then take it to the full UN for its stamp of approval, and then recommend that countries adopt it. So we'll see where that goes. I personally have a number of issues with the way that the law is approaching some of these things, but we'll have to see on that. So with that quick overview, I'm going to turn it over to, I guess, back to you, Tim.
Thank you, Tom. And I can think of a lot of questions here now. I wish we had a 2-hour session. But this topic of reliability is a perfect segue to Stephen Mason, who has spent a career picking over reliability or lack thereof with technology and the interplay with evidence, digital evidence. So Stephen Mason, I'll turn it to you.
Hello, Tim. Yes, thank you very much indeed for inviting me to attend. It's much appreciated. I have to say it was a real pleasure for you to come into central London so I could take you to lunch in the hall in Middle Temple. For those people who are listening, you might not know, but Middle Temple Hall was built in roughly 1557 or thereabouts. So it's a bit old, and it was a real pleasure, Tim. It's also been a pleasure to be invited to take part in this session with Tom and Mike. And I thank everybody for attending, and special thanks to Mallory for the practical organization of this particular thing. Mike, I would say to you, it really is good to have a wider discussion with technologists. I think this is a real problem that we as lawyers perhaps miss out on, or I certainly do anyway. So it's good to hear what you have to say, and I agree with everything you had to say. As far Tom did a great job, as you expect, obviously, setting out the position of the law. So that leads me into look at the what might call trial practical issues and the sorts of issues that I would advise on before somebody set up anything in relationship to identifying people. And I'm guessing and I'm hoping, Tom, that you might agree with me what I have to say. And I'm not going to go on too long because, Tim, you mentioned we've got a lot of good questions. So the value in this sort of session, obviously, is to open it up for questions. So I'll speed through so we can open it up for questions. And I only have those 3 points to look at, really. And that is, you need to think about the integrity of your data to make it sufficiently adequate to prove your case in legal proceedings if you need to, only if you need to. Mike, I think, set this out beautifully, actually, and looked at this from a risk analysis, which is exactly what I would advise any clients do anyway. And I'm sure both Tom and Tim would do exactly the same with their clients. And Tom also touched on certification systems. I think it's interesting about certification systems. What you probably need to do if you're going to rely on a certification system, certainly something I would advise on, and that is if you're going to rely on a system like that, then you might want to consider doing some due diligence on the system and how it's implemented. Implementation itself actually can be quite a difficult problem, and it can be implemented improperly, which could of course cause you problems. And this goes back, my second point goes back to Mike when he pointed about mitigating the risks. I come from, I adopt my position in law is different from a lot of lawyers because I spent 9 years in the British Army in bomb disposal in the 1970s. And my view is always that one actually looks at the risk first. You don't think about any litigation. That's something that comes well down the line if you absolutely have to. If you put mitigation in first, if you really understand what you're doing, then hopefully you'll never have that problem. Having said that, Tim mentioned my book on electronic signatures in law. There's a lot of US law in that as well. And certainly in my research on just electronic signature cases alone, what is interesting, and Tom, I don't know if you know any other examples, but there are very few examples of people challenging whether or not they've signed something in electronic form. Very few. There's lots of problems relating to peripheral issues, but not somebody saying that was not my signature. So that is quite an interesting observation to make, actually, in the context of this discussion, Tim, I think. One thing I would say, Mike, about biometric measurements is that the problem is that once you have a digital file of a biometric measurement, a hacker could steal it, a state hacker or just any old hacker. The point is the biometric of your finger or your thumb or your iris is a series of ones and zeros, and it can be misused. And I certainly have used that in my second espionage novel, where MI6 was able to hack into a Russian system with the biometric of an iris of a suspect Russian oligarch. Whether or not it would have been actually successful, of course, is another matter, but that was fiction as opposed to real life. I'd also, I don't know if anybody, quite a lot of people know about ransomware now. It's very big on everybody's list. And I don't know how many people listening to our session right now know of Brian Krebs, the chap online, the security guy. I actually have an email from Brian. When he sends them, I list it. I watch his website as much as I watch Bruce Schneier's website. And on the 19th of July, he sent an email around with a page on his website don't want to pay ransom gangs test your backups. So he asked the question, if you're subject to a ransomware attack, what do you do? Well, you just go to backup. But people have been discovering that it might take 3 months continuous because you've got so much data to back up your system. So it's cheaper to actually do pay the ransomware, and that could be something that affects people in due course. So that is part of my suggesting about mitigating the risks. Do think. Sorry, forgive me. My screen goes blank every now and then because my telephone keeps on asking me to have a mobile telephone associated with my smartphone, and there isn't. And my last point is knowledge of digital identity principles, which Tom has already outlined. But it is essential, I think, to understand how systems work and also the different types of forms of electronic signature. A lot of people still don't know much about that, and it's something that actually merits getting to know and become familiar with. And just to finish off, to allow for some decent time for questions, Tom, I think, really did emphasize and point out about the need for reliable systems. That I would concur with, Tom, completely. And that goes back to maybe Mike's point about, where is your risk? How do you mitigate? How much money do you spend on it? To what extent are you prepared to adopt resources in order to ensure that your risk is fully covered? That will obviously depend very much on how much is at stake and what you're doing, but it is something that is obviously well worth investing in. So Tim, I'll leave it at that, and then let you hand over to questions and see how we go from there. How about that?
Stephen, that's great. Thank you. And I'll certainly have in mind 5 minutes for Mr. Bisbee, Stephen, to make his comments. So I have a question for Mike. To explain, there's a lot of talk about with digital identity systems, centralized versus distributed versus decentralized. And this comes up quite a bit in my participation with human rights communities around the world. And there, for example, as you know, there are entities that are advocating for self-sovereign identities as a type of decentralized identity that's. So how, in your mind, do you see these, are these distinctions without a difference really, or they make a huge impact? And then what would be the impact on the reliability calculus or in evidence and recognition?
Yeah, it's a great question and a hot topic. I'm a bit of a naysayer on some of these sorts of things quite often because I think when the conversations that we have around them often miss the point. And so I'm really glad that you asked this. The reality is that from the perspective of a service provider, right? If I'm trying to establish someone's identity because I have a requirement, whether it's legal, whether it's for my own liability purposes, whether it's because I've done a business profitability calculation and determined that I needed to know who they are before I transact with them due to risk of loss, or reputational damage. I also have a decision to make on what I trust from them in proving their identity. And so if you look at some self-sovereign identity that somebody is effectively running their own identity and attribute system from their basement, that's great. If you trust that, then feel free to trust that. And if someone decides that they don't agree with that and want to try to put some liability on you for having made that decision, well, that's your decision. And you may be under regulations, obviously, that prohibit that sort of thing, require that it be from one of the U.S. states or territories that there be an identity provided. The federal government, requires that you use a federal ID card, even if you have a state ID card, if you're an employee. So these are the fundamental thing here is really about what the root of trust is. And so a service provider that's offering a service has to make that decision. And again, it may be made for them through regulations, but the reality is that you decide what evidence gets brought to you that you're willing to accept. And so it's kind of this, we retain the right to refuse service to any customer, Well, if you show up with, if you don't believe that some self-sovereign identity that someone comes with is good enough for you to make that trust decision, then you reject it. And so the whole argument around, is it centralized or decentralized, I think largely misses the point that that you are subject to the regulations and liability you're subject to. And you have to make a business decision about what you're willing to accept and what you're not willing to accept. And you have to be comfortable with that decision. And so at some point, whether that's centralized or decentralized, what word we assign to it is irrelevant. It's about where you believe that that an appropriate trust decision can be made.
Oh, thank you, Mike. That is great. And related to that, I turn to Tom Spenningoff. The concept of reliability, you mentioned, is such a key one to the UNCITRAL model law and all. Is there a place for human rights considerations in the concept of reliability? And again, I asked this just from being part of discussions worldwide with the human rights community and the various abuses going on with authoritarian regimes using digital identity to control access and so forth. Would you see any legal or policy basis with human rights considerations, how it might fit into the UNCITRAL discussions of reliability?
Okay, well, first, and I guess generally, let me say that the UNCITRAL law doesn't directly address that issue, nor does it directly address privacy issues. It leaves those to other law and policy decisions. So but it recognizes that those are very controversial issues, that doesn't necessarily dismiss them, but just doesn't address them, recognizing that they need to be addressed elsewhere. But having said that, yes, well, centralized identity systems are often criticized because, the issue is who controls the identity information. I mean, there's of course an issue of security, but beyond that, if the identity information is controlled by the government, such as you have in India, that was a big criticism of the Aadhaar system in India, you get into a lot of questions about what is this information being used for, and is it being misused? And really coming up with appropriate rules and regulations and legislation, I think is going to be critical there. I mean, that was the traditional example you hear is when the Nazis took over the Netherlands during World War II, and the Dutch had a very complete and comprehensive, I mean, all based on paper, of course, but identity system where they identified their population and the attributes that they included, of course, included nationality and religion and things like that. So the Nazis were easily able to take that information and seek out all of the Jews in the Netherlands. So that's the kind of basic concern I think that's out there. I mean, and there's many other things, of course, that can be done. I know the World Bank, for example, works with many developing countries, assisting them in developing national identity systems, because having an identity is so important to functioning in society and getting an education and getting healthcare and so forth. But they do keep an eye on that issue because, you've got to balance it. So I guess I'll leave it at that.
Oh, thank you, Tom. And then Stephen Mason, last question related to that. Our training as common law lawyers in all the common law countries, the role of individual autonomy tied to legal responsibility. Are you concerned about this with the digital identity systems, how they're set up? How are we going to continue to base our legal system on tying legal responsibility to autonomy if the control of the credentials and all is in doubt? Sure.
Yes, thanks, Tim. I think it's a central question of the 21st century, actually. And it's a much wider question, as I'm sure the questioner realizes, than just within the digital identity, but it's also certainly in what we might call a democratic free West, where commercial organizations control so much of our personal information because of our use of the internet, but also in other regimes where they control it through state control, as Tom mentioned. And there's been an incredible shift of power, which is actually very disconcerting. And I don't see, if I just look at my own jurisdiction of England and Wales, politicians actually giving enough care and attention to this particular topic. And the problem is our personal autonomy is beginning to be eroded quite rapidly now because of the digital regime. And also, just to extend that a little bit further into what is euphemistically called artificial intelligence, which actually is not really artificial or intelligent. It's more algorithmic intelligence. I have a very pessimistic view of the future in the failure of politicians to actually grasp this. There are obviously quite a lot of organizations and policy organizations around that are cognizant of this particular issue, but whether or not we manage to actually do something which actually protects our identity is another matter. I'll just give you very briefly a couple of examples. I have now logged onto two email systems, one based in Switzerland, which I use, called Proton Mail, and the other in Germany called Tutanota. So I use those rather than any other email solution providers now. Both encrypt their emails. They're both subject, obviously, to problems one way or the other, but one could argue to a certain extent that that's one small step for an individual. I think it's a political problem, and I think Tom, I wonder if, Tom, you put this on the agenda in the UN. If you haven't, then maybe we'll try to. But great question. I haven't got a clear answer for it, I'm afraid.
Well, thank you, Steve. That was really great. And I think we're down to a minute here. Thank you so much to the panelists, and Mr. Bisbee, I think, would like to wrap up the session. Thank you so much.
Thank you.
Tim, first, thank you, and Mike, and Stephen, and Tom. This has just been fascinating. Ezra, the digital identity issues have been really taking up a great deal of effort at Ezra, along with remote online notarization. And this was, as you said, we could do this for 2 hours easily, and maybe we should find a way to revisit this. But as our time is really up, I just wanted to note that we have a lot of other topics coming up in our digital 2021 educational series, and everyone can find out more about Ezra and the series on our website at www.esignrecords.org. And of course, we encourage you to join Ezra and gain the benefit of the combined expertise of our members and panelists such as you heard today, and also support our advocating for a trusted digital economy for all. And on behalf of Ezra and our speakers and our panelists, thank you very much for joining us today.